Good afternoon everybody and welcome back. First, let me apologise for the long break since I've posted anything up. A couple of reasons for that. Our house got burgled in October and we're still dealing with the fallout from that. And I teach an accident prevention course at Curtin University here in Western Australia, and unfortunately around November I get a confluence of the second assignment in the unit and the exam paper. And I've got about 75 students in the unit at the moment, so I've been marking 75 assignment 2s and then simply rolling over into 75 separate exam papers. So that's the reason, not an excuse, and I apologise, but I've got some interesting case, or an interesting case I should say, to look at today. The Kalgoorlie Consolidated Gold Mines case, or KCGM, a Supreme Court of WA case looking at a fatality in a mine site. And I've got a few other presentations backed up, so over the next few weeks you'll get a fairly regular run of the cases in this Contractor Safety Management series, which hopefully we will round out in early January and then move on to another topic. Just a reminder for everyone, it has been a while. The discussion that we're having today is of a general nature, looking at some legal risk management issues and safety risk management issues falling out of the case. The information in this presentation is not legal advice. You shouldn't take it as legal advice. And as always, if there's anything that comes out of the presentation that causes you concern, I would encourage you to go and speak to your legal advisors and get some advice on the matter. Okay, again, the factual scenario in this case was quite straightforward, if a little bit horrific, I guess. KCGM was the mine owner of an open cut mine in Western Australia. The victim in this case, or the deceased, if you like, Mr. Harris, was an employee of a company called Ausdrill, and Ausdrill had been engaged by KCGM to do drilling in the open cut mine. Early one morning, while it was still dark, Mr. Harris was driving his light vehicle, so a utility four-wheel drive type vehicle, in Ausdrill's yard on the mine site. I'll say a little bit about that in a moment. It was dark, and unfortunately he drove his light vehicle in the back of a truck. As I understand it, it was an Ausdrill truck, and it had drill pipe that was used for the drilling, obviously, exercise that they were carrying out on the mine site, sticking out from the back, protruding from the back of the truck. And he drove into the drill pipe. The pipe came through the windscreen of his vehicle, hit him in the head. He was obviously travelling at some speed. He suffered quite severe injuries, and ultimately he died from those injuries. Now, as with prosecutions for health and safety breaches in Western Australia, they start in the Magistrates Court. And so at first instance in the Magistrates Court, KCGM was convicted and they were fined $160,000. KCGM appealed to the Supreme Court of Western Australia, and both the conviction and the penalty were upheld. Now, I'll work through some of the reasoning of the court in a moment, but I think the really simple takeaway from the KCGM case is that when we start imposing safety requirements on a contractor, if we start telling them, when you're doing work on our site or for us or on our premises or in your premises for us, and we start saying, when you work for us, this is how you must manage safety, we own those, we own those things. So if we impose health and safety obligations on our contractors, we are responsible for both the quality of those obligations and ensuring that those obligations are complied with. And one of the interesting things that comes out of the case that I think is worth really having some regard to on the way through is, what does it mean if we are approving a contractor's system? Does that create any particular legal exposure for us? I think the short answer is it does, and we'll have a look at how it plays out in this case. Now, I touched on this before, but just to reiterate, the incident occurred inside of Ausdrill's yard on site. It's not entirely clear from the case, but as I understand it, This was a typical mine site setup, lots of different contractors on site doing different things, and Ausdrill had their own yard with their own shed. I think it was a fenced off area, and within that they had a designated parking area for their vehicles, including trucks with their drill pipe. And one of the arguments that was run by Ausdrill, and you'll see it in the case, one of the arguments was run by KCGM, was that Ausdrill had their own designated processes for parking and driving, so they had submitted their own plan for dealing with these things, and fundamentally what happened in their backyard was their responsibility. And ultimately the court simply didn't accept that for a whole range of reasons we'll touch on now. One of the concepts we've been looking at quite a bit in this contractor safety management series is the notion of control. And we've seen how the notion of control is very important in defining, in particular, a principal's obligations to its employees. And I think, as a very basic rule of thumb, the more control that a principal exercises over its contractors, the more it is expected to do. And I think the higher level of control that a principal exercises, the more things it can reasonably be expected, or the more things that would fall within the scope of reasonably practicable things that a principal could do to ensure that its contractors are not exposed to harm. So in this case, when the court was forming the view that KCGM had breached its obligations in relation to its contractors, they made a number of interesting observations. The first one was that driving rules were very important on site. And you see that a lot often in principal-contractor relationships. If you're a contractor and you're coming onto my site, these are the really important rules that we have on site. And there's nothing untoward or unsurprising about that. KCGM had a traffic management plan, again nothing unsurprising there, but interestingly contractors had to submit their traffic management plans to KCGM for approval. Once again, in mining and oil and gas and many high hazard industries, that is not unusual. It is quite typical for a contractor to have to submit their safety management plans or elements of them to the principal for approval. But what I think that approval process does is that it increases, or at least starts to engage, the notion that the principal has a high area of, or a higher element of control in relation to the risk. Now, we've also touched on this twin concept of control and expertise. And the thing about the traffic management plan, and as a point that's made in the judgment, there is nothing about the traffic management plan that fell exclusively within the expertise of Ausdrill. So I think if Ausdrill were providing a plan to KCGM to do with the technical aspects of drilling that fell wholly within the expertise of Ausdrill, I'm not sure that that would really do much in relation to the control that KCGM might have exercised. But when we're talking about a risk that is important to KCGM, KCGM clearly had expertise in the risk because they had their own plans. Ausdrill then submits its plan within the context of KCGM's plan. In those circumstances, which are again not uncommon, I think the level of control and the expectation on the principal increases. That point, in my view, is emphasised in the case. The court found, and the evidence was pretty clear, that breaches of driving rules left employees of KCGM as well as contractors open to disciplinary action. And I think that the common sort of expression of that is when a contractor breaches a safety rule on site, they're kicked off site. Well, if a principal can exercise that level of control over their contractors and boot them off site for breaching safety rules, that speaks to a high level of control, which carries with it a fairly high level of responsibility. And dealing with specifically that issue that was raised about what happens in Ausdrill's yard is Ausdrill's business, the court said, well, hang on, here's all the evidence that you actually dealt with and regulated other areas of safety within Ausdrill's yard. So you can't have it both ways. You can't go into a contractor's workshop or premises and do audits and do inspections and do investigations and whatever other checks, but then say, but it's their responsibility. And again, it feeds into the perception of the level of control that a principal is actually exercising in relation to its contractors, and what that means in terms of responsibility and what we ought to be doing to really enforce our safety expectations. I think one of the interesting things to come out of the case is the court looked at both the quality of the rules that were imposed, if you like, by KCGM and the enforcement of those rules. Now, the enforcement is a pretty common issue. There's nothing particularly surprising in that, but I'll touch on it in a moment. But one of the issues that the court identified was that KCGM had rules in place to deal with overhanging loads on vehicles that were moving around its mine. The court said, however, KCGM had no rules to deal with what was described as the obvious risk or the obvious hazard of overhanging loads on parked up vehicles. So they said the hazard was obvious, overhanging loads on parked up vehicles. There were rules in place to deal with overhanging loads when driving, but not when parked up. The evidence was that KCGM agreed that the practice of leaving overhanging loads on parked vehicles was high risk, and that if they were aware of it, they would have taken action. There's one extract of evidence in the case that's worth looking at where the KCGM position is fundamentally that they assumed that overhanging loads would be removed. And I don't know how many fatalities have occurred and then how many legal cases have been lost based on assumptions. So interestingly enough here, the court was actually questioning the quality of the safety rules that KCGM was imposing on its contractors, and it's saying there was an obvious hazard and you ought to have had a rule or a procedure or a process or a control that dealt with overhanging loads on parked vehicles. And then over and above that, the evidence was clear that the process was not complied with. The procedure required that overhanging loads being driven around at least needed to have flashing lights attached to them. Equally clear, the evidence was that Ausdrill used red flags. So Ausdrill weren't complying with the procedures. KCGM's evidence was, well, we weren't aware of this breach and we would have taken steps to stop it if we had of been aware. All of that leads into another interesting question of whether KCGM ought to have been aware of breaches of these rules. And again, there's nothing particularly challenging about that question, and employers need to ask themselves that question all the time in relation to their own employees. Should we be aware of when employees are breaching important fundamental safety rules around our site? Well, the answer to that is clearly yes. And it goes to levels of supervision and checking and a whole range of things we won't touch on now. But for the purpose of this discussion, we need to ask ourselves the same question in the context of our contractors. So if we are imposing rules on contractors, should we be aware of when they are not breaching or when they are breaching those rules? And I think the short answer to that question is yes, we should be. The long answer and the intellectual exercise is how much checking do we have to do before we've met that obligation? We might look at that in a later discussion. In effect, the substance of the failures and ultimately the substance of the findings against KCGM was that the control was inadequate. So the processes imposed by KCGM didn't deal with overhanging loads when the vehicles were parked, even though the hazard was an obvious one. So the control itself was inadequate to manage the hazard, and over and above that, the control was not enforced. And that is a common theme throughout many of the cases that we've looked at, and indeed most major disasters around the world and individual fatalities in individual work sites around Australia for as long as I've been involved. in safety law and safety management. And just to drop back to that question I asked a moment ago about what KCGM ought to have known, the court said that the point raised that KCGM did not know that Ausdrill was not complying with their instructions begs the question whether a reasonable person in the position of the owner of the mine ought to have known. And I think in safety management this is a question that we probably don't ask ourselves often enough. That continual unease, mindfulness, whatever expression you like to use, constantly asking ourselves the question, what ought we know about, what do we actually know? And where the court landed on this was that they said, well, look, if balanced against the severity of the harm, KCGM ought to have foreseen the risk. They said the findings not only open on the evidence, but one I consider is inevitable on the evidence. And I think when you look at these sorts of value judgments that the court has to make, a lot of it does boil down to the severity of the harm. And the evidence in the case was clear. I don't think there was anybody or any argument run, certainly there's nothing on the face of the judgment that you could point to where anybody tried to argue that the risk of overhanging loads on vehicles parked up wasn't obvious and the likelihood of a severe injury or fatality wasn't obvious. In fact, the evidence all went the other way. The evidence was it was an obvious hazard and the severity of harm presented by that hazard was also obvious. And I think that in those circumstances, the court is entitled to say, well, given that you had policies and procedures that dealt with a whole range of things around this risk, it is, in our view, the court's view, a more than reasonable position to take that you ought to have seen the risk posed by this particular hazard, and you didn't, and your failure to do that effectively means that you haven't done everything reasonably practicable to manage your obligations in relation to your contractor. And again, the takeaway from this, if I circle back to the start of the presentation, what should we make of this sort of a judgment? I think quite clearly and obviously, if we impose health and safety obligations on our contractors, we are responsible for both the quality of those obligations and ensuring that those obligations are complied with. I think the question, or I guess the intellectual challenge that falls out of this sort of discussion is, what are the risks that are wholly or as a principle, what are the risks that I believe fall within the expertise of the contractor, and I should just leave the contractor alone to manage and get on with those risks? What are the risks that I believe are within my expertise and I need to manage and make sure the contractor understands and complies with them? And then probably, the quintessential safety management question that doesn't get dealt with well in contracting relationships, but it doesn't get done or dealt with particularly well in employment relationships either, is what should I be checking and how often should I be checking to get assurance that the processes that I say are in place to manage the health and safety risks in the business are actually in place, they're being implemented in the workplace, and that they are effective to control the risk. And I think every case that I've put up in this blog over the last 12 months, at its heart, I think the failure is a failure of checking and assurance, and the lack of adequate assurance to understand that the controls that we have in place are in fact, not in theory, not from a systems point of view, but in fact effective to control the risks in the business. Again, thank you for tuning in again. I hope I haven't lost too many people given the length of time since we've run the last presentation. But again, thanks for calling for watching in. If you want a copy of the case, you can click on the link there. If this is the first time you've come to us and you want to get updates and receive information about these presentations on a regular basis, you can follow the blog If you click on the link, it will take you to this page, and you can see up here in the top right hand corner, if you just put your email address in there, you'll be following the blog, and you'll get an email every time we post up a new video presentation.